We recently had a case where our client was accused of a triple homicide. He was sitting in his home one night when he heard some noise outside. His dog had started barking, and he was concerned about that. He lived in a rural area in San Bernardino County. He armed himself with a handgun. He went outside, and as he was walking, he heard some movement. He saw some movement, but he couldn't tell what it was. And what he later learned was it was 3 people who were there to do harm to him, to attack him. They were armed with rocks. They came upon him strategically by moving from the left to the middle and the right. One of them actually grabbed him and attempted to choke him. He could see a rock in someone's hand, in the third person's hand, and he took out his gun and he shot them. He shot all 3 of them. All 3 died at the scene on his property. Police came, they investigated the case. Our client was immediately arrested for triple homicide. He remained in jail for over 18 months while we gathered evidence to prove that what he did was reasonable under the circumstances. And one of the things that we did in that particular jury trial, which ended very successfully for our client, was to put the jury actually into the shoes of our client. We try to do, when we're talking to jurors, is not only let them listen and see and hear what the evidence is going to be, we want them to feel it. For example, I not only talked about our client being punched in the face and having blood in their mouth, I told the jury what he felt. The reason he first knew he was hit and injured, he felt it, and then he could taste his own blood. It was hot, it was salty. It's that taste that if you've ever tasted blood, you know what it tastes like, you know what it feels like. And by doing that, we bring the jury into exactly what our client is feeling. The jury was out 2 days, and they came back not guilty, not guilty, not guilty. Innocent on all 3 counts. And our client went home that night to his family after spending 18 months in jail defending himself for an unlawful charge. The jury knew, based upon everything that we presented, all the facts that were presented to him, that what our client did was reasonable force and was self-defense.